Judgment in the appeal of TUI UK Ltd against Griffiths.
Mr. and Mrs. Griffiths went with their youngest son on a package holiday to a resort in Turkey. While staying in a hotel on an all-inclusive basis, Mr. Griffiths took ill with a serious stomach upset. He ended up in hospital in Turkey, and the family holiday was ruined. On discharge from hospital, the Griffiths family returned to the United Kingdom. Mr. Griffiths has been left with long-term problems relating to his stomach. Several years later, Mr. Griffiths brought a claim in the county court against the travel company from whom he had purchased the package holiday, claiming damages as a consumer under the Package Holiday and Package Tour Regulations 1992 and the Supply of Goods and Services Act 1982. He argued that the hotel at which his family stayed had caused his illness. It transpired that the central issue in the case was identifying the cause of Mr. Griffiths' illness. At the trial, Mr. and Mrs. Griffiths gave evidence which the district judge accepted as truthful and reliable, and they had had almost all their meals at the hotel. Mr. Griffiths also lodged the report of the distinguished microbiologist, Professor Hugh Pennington, who opined that, on the balance of probabilities, the cause of Mr. Griffiths' illness was food or drink, which he ingested at the hotel. The defendant asked Professor Pennington some written questions under Part 35(6) of the Civil Procedure Rules, which the professor answered before the trial. At the trial, the defendant did not require Professor Pennington to attend court for cross-examination and led no evidence of its own. Instead, in his submissions at the end of the trial, counsel for the defendant criticised Professor Pennington's report for, among other things, failing to exclude alternative causes of the illness and failing adequately to set out his reasoning in support of his conclusion. Counsel submitted that, as a result, Mr. Griffiths had failed to prove his case. The district judge accepted this submission and dismissed Mr. Griffiths' claim, holding that it had not been shown to have been more likely than not that the cause of his illness was food or drink consumed at the hotel. Mr. Griffiths appealed to the High Court, and Mr. Justice Martin Spencer allowed the appeal. But on further appeal by the defendant, the Court of Appeal by majority allowed the appeal and rejected Mr. Griffiths' claim, holding that the defendant's conduct had not resulted in an unfair trial. Lord Justice Bean gave a powerful dissent, reasoning that the claimant had been ambushed and that the trial had been unfair. Mr. Griffiths appeals to this court. Mr. Griffiths' claim is not a high-value claim. The judge valued his claim at £29,000 for pain, suffering and loss of immunity, including the spoilt holiday, plus damages for medical and care expenses. But the appeal raises an important question about the fairness of a trial when a party leads evidence of an expert witness, in this case as to the cause of the illness, and the opposing party does not challenge the expert on cross-examination, but reserves its criticisms for submissions at the end of the trial. This court unanimously allows Mr. Griffiths' appeal. The trial judge had been wrong to accept the defendant's submission criticising Professor Pennington's report when the defendant had failed to challenge the report by cross-examination. This court holds that Mr. Griffiths has proved his case on the balance of probabilities. On the critical question as to the cause of the illness, Professor Pennington's report, although terse and lacking in detail, and his answers to the CPR Part 35(6) questions, which were unchallenged, were sufficient to show, in the absence of challenge, that it was more likely than not that food and drink at that hotel had caused the stomach upset. The significance of the case is not the particular facts or the particular report, but the question which it raises as to the proper way to challenge the evidence of a witness of an opposing party. The court's starting point in this is that courts in this country operate on an adversarial system of achieving justice, in which, subject to judicial case management, the parties frame the issues which the court is to determine. It is a well-established rule that, as stated in Phipson on evidence, in general a party is required to challenge on cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that that evidence should not be accepted on that point. This proposition is supported by case law going back at least 200 years. At heart, it is a question of the fairness of the legal proceedings as a whole, encompassing fairness to the party who has adduced the evidence and fairness to the witness whose reputation may be at stake. Cross-examination gives the witness the opportunity to explain or clarify his or her evidence. It also enables the judge to make a proper assessment of all the evidence, which itself is a contribution to the fairness of the proceedings. The general rule extends to witnesses of fact and expert witnesses. The court holds that the general rule should not be applied rigidly. It is often disproportionate to cross-examine at length on every detail. The criterion for applying the rule is the overall fairness of the trial. There are also circumstances in which the general rule does not apply. In the judgment, I list 7 examples. They are where the matter is collateral or insignificant, and fairness to the witness does not call for there to be an opportunity to explain. Also, where the evidence of fact is manifestly incredible. Thirdly, where an expert reaches a bold conclusion which is wholly unsupported by his or her reasoning. Fourthly, where there is an obvious mistake in the expert's report, such as an ex facie illogicality or inconsistency. Fifthly, where the expert's opinion is based on assumptions or an understanding of the facts which are contradicted by the evidence of the factual witnesses. Sixthly, where the expert has already been given the opportunity to respond to criticism or otherwise clarify the report. And seventhly, possibly at least, where there is a serious failure by the expert to comply with the requirements of CPR Practice Direction 35. This court finds that the majority of the Court of Appeal erred in law in limiting the scope of this rule to challenges to the honesty of a witness. In agreement with Lord Justice Bean, the court concludes that Mr. Griffiths did not have a fair trial. Professor Pennington's report was terse and can understandably be criticised for not containing more reasoning, but he provided, albeit brief, further explanation of his thinking in response to the defendant's written questions under CPR 35(6). None of the exceptions to the general rule applied. On a reassessment of this evidence, the court is satisfied that Mr. Griffiths established his case on the balance of probability. This court therefore allows the appeal. The court will now adjourn.